Joining us now is an adjunct professor of patent law at Nova Southeastern Law School in Florida. He is the patent professor, John Rizvi. Thank you so much for coming on to WORD.
Yeah, it's always a pleasure. Thank you.
So I wanted to maybe talk a little history when it comes to Disney and patent law, because it has been extended so many different times through the law because of Disney. But I guess in the simplest terms, next year, will Steamboat Willie's version of Mickey Mouse become public use?
It will. The copyrights are expiring on January 1st, 2024. Steamboat Willie, the original version of Mickey Mouse, is no longer going to be protected, no longer owned by Disney. And
Wow.
anyone can use it.
Yeah, so the history of Disney and extending patent law is really, it's a quite an interesting history, considering the power that a big company like Disney has had in order to lobby politicians in order to extend their protections over their characters over the years. It seems like their luck has run out. How many times did Disney actually were successful in getting Congress to extend protections?
Yeah, several times. And it wasn't just Disney, but because Disney was a huge lobbyist for extension, a lot of people have started referring to these extensions as the Mickey Mouse Protection Act. Copyrights are for limited times. The original duration of a copyright was just 14 years. So it's not a patent which would protect an invention. A copyright is what Disney's using to protect these characters. Now, from 14 years, it was extended to 28 years. And then in 1909, one 28-year term and another 28-year term. In 1976, it went to 50 years after the author's death. And then the last extension was in 1998. The law extended rights to copyrights created by a corporation, and that's where it became known as the Disney Act or the Mickey Mouse Protection Act. 95 years after Disney first published any of their characters, the copyrights expire. So we've had then that's what's happening on Monday. There's no on January 1st, 2024. There's no further extensions. There's no talk of a last-second reprieve. And you stated it right. Luck, so to speak, has run out, and that original Steamboat Willie version of Mickey Mouse is now going to be part of the public domain.
Yeah, and it's happening right at a time when AI makes it so easy to create art. So let's look at Mickey Mouse as a character. I'm just kind of curious what people can and can't do. So we looked at an example that happened earlier, which was the Winnie the Pooh case, where someone used that character and made a horror movie out of it. But it was almost like I wouldn't say it was the exact character, but it looked like an artistic rendition of the character that everyone knows. So they were able to do that with some immunity, knowing that the Winnie the Pooh character went into the domain of the public. So when it comes to Mickey Mouse, what can and can't people do with that character now?
Well, one thing to keep in mind is that Disney has more than one version of Mickey Mouse. So what we're talking about is the original black and white Steamboat Willie version of Mickey Mouse. That's what has expired. One of the more recent versions of Mickey Mouse is one that a lot of kids actually visiting the theme park think of when they think of Mickey, and that is with the Mickey Mouse with red shorts and white gloves. That version of Mickey Mouse is not expiring on January 1st of 2024, but it's not that far off. That's 2036, January 1st, 2036. That version of Mickey is also going to be part of the public domain. So as far as what people can and can't do, right now you want to stay away from any version of Mickey that has the white gloves, red shorts, or looks like the more recent version. And certainly, if you are going to use the Steamboat Willie version of Mickey Mouse, that's fine. But remember that they still have their branding rights under trademark law. So if you're going to sell merchandise using Steamboat Willie, you have to be careful not to that Disney can't claim that their consumers are confused and believe that they're buying a Disney product, and some sort of labeling or something that not affiliated with Walt Disney or something on the product, so that a consumer doesn't believe it's a Disney product, and that's what's going to help, in Disney's mind, help, of course, protect their commercial rights to their trademark, but also protect their image. That's a concern they have as well. So if there is a slasher Mickey film that comes out, they can't do anything to stop that, of course, because the copyright's expired. If they use Steamboat Willie and Mickey and Minnie from that version, nothing Disney can do to stop it, but they can take action if they believe consumers are going to believe that this film is created by them. So you do have to have enough disclaimers that there's no confusion that this is a Disney film.
Yeah, it's so fascinating how all of this works. So you kind of answered one of my questions, I thought, for a moment. There's Steamboat Willie merchandise that is affiliated with Disney. I think about my kid who loves Legos. There's a Lego set that's a Steamboat Willie with the exact same character. So it's like the affiliation with Disney would still mean that you'd have to get approval because of that affiliation. But if you were to just create, let's say, a set of something that used that character, not affiliated with Disney, and disclosed it, could you still sell it, or can you not make money off of the Steamboat Willie?
You can still sell it. You can still make money off of it. It just has to be clear to the consumer that it's in no way authorized by Disney, affiliated with Disney, that Disney has no connection with it whatsoever.
Wow.
So that if there's any harm that comes from it, it's not Disney's reputation that suffers.
I'm guessing there's a lot of lawyers involved when it comes to Disney's side. Do you think Disney will still try to sue people, hoping that people would just back down automatically? Or do you think that, as a lawyer, knowing that you're filing a lawsuit that you're going to lose, could you get in trouble for that?
Yes, well, certainly. I mean, if a lawsuit is frivolous, you cannot file a completely frivolous lawsuit. You have to have a good faith basis in law or fact. But that provides a lot of leeway for Disney's lawyers to sue for infringement. Anybody can sue anyone for anything. So they do have a deterrent, being that it's Disney. So a lot of people may, especially larger companies, may avoid selling products where they believe Disney is going to aggressively try to pursue infringement claims. So Disney does have that to their benefit. They have a reputation for aggressively protecting their intellectual property. But once something's part of the public domain, if it ever gets to court, they're not going to be able to maintain protection on Steamboat Willie. The only chance they would have is if they can try to show that their customers are confused, consumers are confused, and believe that they're buying a Disney product. Like, say, for example, somebody starts selling a Steamboat Willie candle, and the consumer cannot believe that they're buying a Disney product. It has to be made clear in the packaging that, yes, it's Steamboat Willie, but they're not purchasing something associated at all with Disney, and that Disney hasn't even licensed rights. And that's,
right.
That's a lot of the revenue comes from licensing. You can go to Publix and you can buy, say, a Snow White a cake, and Publix is licensing rights to do that, and they have to because those copyrights are still in force. But if you wanted to have Steamboat Willie put on a cake from Publix or any other bakery, you would no longer, after January 1st, 2024, you would no longer have to get a license from Disney in order to do that. It's part of the public domain. Anybody's able to do it. The only thing you can't do is confuse consumers and mislead them into thinking that they're somehow buying something affiliated with Walt Disney.
So just real quick, can you screen a film of Steamboat Willie without getting in trouble from Disney? So something that was created during the time, because I know Disney doesn't like you screening their films without paying them something. But let's say you did the original film. Could you do that?
Yeah, sure. That's part of the public domain now. It's the copyrights have expired.
Okay, so if you want to put it up on the big screen without Disney's lawyer sending you a letter, I know that's happened before. The patent professor, he's an adjunct professor of patent law at Nova Southeastern Law School in Florida, John Rizvi. Thank you so much for coming on to WORD, and enjoy Steamboat Willie while you can next year.
Exactly, a couple more days before it's part of the public domain.
Yeah, by the way, if people wanted to find you as the patent professor, where can they look?
Yeah, so our handle is the Patent Professor everywhere. That's our website on Facebook, Instagram, TikTok. Just type in the Patent Professor and you'll find us.
When does your copyright protection expire?
Because we're intellectual property lawyers, we continuously renew its trademarks, and every 10 years they get renewed. So no no intention of letting it expire over my dead body.
Steamboat Willie, the Patent Professor. Maybe you can incorporate him into your branding next. Who knows? John Rizvi, thank you so much for joining us here